And today we'll call this meeting of Senate Finance to order. And on our agenda this morning we have two bills, and then we also have some BDR introductions, and then public comment. We'll probably end up recessing when we're done here as opposed to adjourning, because we have a few BDRs that are coming in this morning that we need to introduce, and we'll have to hang out and wait for those to get ready to bring them back. But we'll start with Assembly Bill 4.
Mr. Chair?
Yes, sir.
Would you like me to call roll?
Oh, we're all here.
Okay.
No, yeah, go ahead, though, please. Oh, Senator Hammond's not.
Senator Dennis, Senator Kekeffer, Senator Goycochea, Senator Hammond, Senator Ratty, Senator Severs-Ganser, Senator Cannizzaro, Senator Dondero-Loop, Chair Brooks.
Here, thank you for reminding me. So we will start with Assembly Bill 457, and Assembly Bill 457 makes an appropriation to the Division of Forestry of the State Department of Conservation and Natural Resources for deferred maintenance projects. And I'm not sure if we have anyone here. There we are. Good morning.
Good morning. Chair, members of the committee. For the record, I'm Allison Kellogg, Support Services Manager for the Nevada Division of Forestry. Thank you for inviting me today to provide testimony on AB 457. This bill, as reprinted, requests an appropriation of the State General Fund to Nevada Division of Forestry in the amount of $637,890 for deferred maintenance projects. This request would fund the 50 highest priority deferred maintenance projects that deal with life safety and/or ADA compliance in NDF's 3 regional headquarter facilities, 2 interagency dispatch centers, helicopter hangar, and maintenance shops. The agency has a backlog of deferred maintenance beyond this request of 102 additional projects, adding over $1.9 million additional dollars. Due to the age and condition of all NDF facilities, often prioritized projects are replaced with immediate need emergency repairs, further delaying our deferred maintenance needs. Thank you for your consideration of AB 457. I would be happy to take any questions.
Thank you very much. Do we have any questions from the committee on Assembly Bill 457? All right, I do not see any. Thank you very much. Have a good morning, and we will
Thank you.
See if we have anybody in support of Assembly Bill 457 on the phones.
Thank you, Chair Brooks. The public line is open and working. However, there are no callers at this time.
Thank you. Do we have any callers in opposition?
The public line is open and working, and there are no callers at this time.
All right, so no callers in support, no callers in opposition, no callers in neutral. And so with that, we can close the hearing on Assembly Bill 457, and we can open the hearing on Assembly Bill 480. Assembly Bill 480 revises provisions governing legal services for indigent defendants. Good morning. Welcome. And if you'd like to start with presenting Assembly Bill 480.
Good morning, Chair Brooks and members of this committee. My name is Marcy Riva. I'm the Director of the Department of Indigent Defense Services. I'm here with Jared Hickman, who is the Deputy Director.
Good morning.
The intent of AB 480 is to balance the scales of justice statewide for indigent defense. The bill proposes to create independence from the judiciary for indigent defense providers, which is already the practice in Washoe and Clark. Remove economic disincentives to providing effective indigent defense representation, and provide clarity of public defender duties. The department believes the fiscal impact cannot be determined. Specifically in Washoe and Clark, there will be no fiscal impact, as they entered into plans in 2008 complying with these requirements. In the rural counties, The counties are in the process of creating their plans, which are due on September 3rd, and any fiscal impact will be dependent upon the plan. For historical information, in 2008, the Nevada Supreme Court issued Administrative Order 80KT 411 to provide consistency and improve indigent defense services throughout the state. Ultimately, Clark and Washoe entered plans for the provision of indigent defense services in compliance with that order. However, rural counties were given a stay to enter a plan until such time as provisions were made by the court or legislature for the creation of a flexible statewide approach for indigent defense service delivery that balances the need for state oversight with the need for local autonomy. With the creation of the Department of Indigent Defense Services in 2019, such a system was created. Within the department is the Board of Indigent Defense Services, which has adopted temporary regulations effective March 2021. The regulations provide for the creation of a plan for the provision of indigent defense services in each county, similar to what's required under 80KT 411, and recommend indigent defense independence from the judiciary as is proposed in this bill. Independence from the judiciary has been recommended by the regulations, but is not fully required without a change in the law. And if you'd like me to go into more specifics about the sections, I can do that, or I'm available for questions.
Thank you. Do we have any questions from the committee on Assembly Bill 480 for Ms. Riva or Mr. Eggman? Senator Severs-Gansert?
Thanks, Chair Brooks. So I'm looking at the digest, and then I'm looking at the bill, and it looks like there was a cap that was taken off of what could be paid, but I'm not really reading that in the bill. It looks like it was 125 for the death penalty, 100 otherwise, and but it also points to the plan that you just discussed. I guess each county has to come up with their plan. So is the plan, does that create the limiting factor on what can be paid as far as fees?
Thank you to Chair Brooks, or to Senator Gansert through Chair Brooks. That's a great question. So the caps are still in there. It is still $100 an hour for cases other than death penalty, and death penalty cases are $125. What's removed is the economic disincentives to providing effective representation. If you set a limit and say you're only allowed to spend $750, which is equivalent of 7.5 hours on a felony case, the felony case might need more work than that. So this encourages attorneys to do what needs to be done in their case. It also removes from the judiciary the ability to approve or disapprove of those fees. Right now, the judges can allow attorneys to go over that amount if necessary and increase those funds. And we have to remember also that this limitation is only when the public defender actually has a conflict. Because a public defender is an employee, so this doesn't necessarily apply to them. But if there's a conflict and counsel is appointed, they're paid on an hourly basis. And this encourages the removal of that economic disincentive. And it's also encouraged by the state B. Davis settlement judgment, which was entered by the state.
Thank you. I appreciate that answer. And then does the plan govern overall how this works in each county?
Yes, the counties are in the process of putting together their plans, and they'll decide whether it's our department that approves and reviews these bills or whether or not it's a designee from each county. So we'll work that out when we're talking to the counties. Ultimately, if the attorney disagrees with our review of the bill, they do have the ability to go to the judge and challenge what we've determined under the way the bill is written.
Thank you.
Senator Dennis.
Thank you, Mr. Chair. So based on that last discussion, is that the same in that you're crossing out the $500 for the investigator or expert testimony? Is that why you're eliminating that?
Through Senator Brooks to Senator Dennis, what we're trying to create is some independence so that the attorneys don't necessarily need to go to the judge. We want the same oversight of public defenders as are provided to private counsel or as are provided to prosecutors. Prosecutors don't necessarily need to go and ask for funding from the judge to be able to work their case, and we're hoping the same can be true for public defenders. So what would happen here is if a public defender didn't have an investigator, which we're encouraging counties to consider hiring investigators for public defender offices, but if they didn't have one, they could either come to our office or our designee to request funding to be able to cover those expenses, and they wouldn't be limited by a cap.
Great, thank you. Thank you, Mr. Chair.
Senator Gocochea.
Thank you, Mr. Chair. And I guess I'm just, in the interim from now until September, then they'll be running under, especially the rural counties, they'll be running under their existing contracts with their public defenders, right?
Through Senator Brooks to Senator Goyachia, that is correct. So counties, for example, Eureka County, they currently have a contract with the public defender, which is going to be allowed to be continued. We just want to write down how indigent defense is provided in each of the counties. You know, who goes and talks to the clients to see whether or not a public defender should be appointed? Who screens that process? Does the attorney need to show up at a certain time? So the contracts are still going to be allowed. There's 3 ways that counties can provide indigent defense services. That could be using the state public defender, creating a county public defender, or using an independent contractor. All 3 of those are acceptable. We're just planning on writing it down so that we have the plan written and in place, as is already done in Clark and Washoe.
Just to follow up, if I may, Mr. Chair, and then I believe in White Pine County, they have a full-time public defender hired. Is that, so I think that's the difference between the two. And in Elko, they might even have a couple, correct?
In Elko County, they actually have an established public defender office. In White Pine County, they have 3 independent contractors that share the bill. So one thing to address in White Pine County is, how are cases assigned? When you have 3 attorneys in separate offices, who decides who gets which case? And that's something that we're hoping that this bill will set out. We don't necessarily want it to be the judge, because we're trying to create that independence. We want it to be a separate body, either our department or possibly an appointed court administrator in each of the counties.
All right. Thank you so much. Thank you, Mr. Chair.
Thank you, Senator. Do we have any, Senator Dondero Loop?
Thank you very much, Mr. Chair. Why do we use so many independent contractors, whether it's Clark County or White Pine?
Through Senator Brooks to Senator Dondero Loop, I think that the key in the creation of our department is to allow state oversight, but allow that flexibility for counties to have the ability to choose. If it works better for some counties to use independent contractors, they still have the ability to do that. Independent contractors are necessary when there's conflicts for a certain case. There's ethical responsibilities where you're not able to take a case for a certain reason. And if the public defender can't take it, for example, in Washoe or Clark, it would be conflicted off to the alternate public defender. If they also have a conflict, it'd need to go to an independent attorney to be able to handle the case. So it just depends on the ethical rules and whether or not there's a conflict.
So the conflict is the key there, not just we don't have enough people in the office?
Correct. Generally, it's a conflict as to why it gets out of the office, but in the rural counties, some rural counties are choosing to use independent contractors rather than create an organized office, an organized county office of public defenders or a state office. Some counties don't feel that they have a full-time work for a public defender, so they'd like to have that opportunity to do private work. And that's the way that some of the rural counties feel that they can incentivize the attorneys to come out to the rurals by saying you can also do private, and it covers their needs, because rural counties not only need criminal attorneys, but they also need attorneys to assist with wills and trusts, family law, and all those other things. So it just creates that opportunity as well.
Thank you.
Thank you. Do we have any other questions for the committee? Senator Goyachia, go ahead.
Thank you, and I just need to clarify for the rest, you have to understand, in a number of these, even if it is a Lander County or, a Lincoln County, there's just not a lot of attorneys there. And, it clearly helps if you have that contractor coming in, because he can pick up some stuff on the side and actually provide a service to the community. So, Battle Mountain, I don't care, Ely's got a few more than, I guess it's just the nature of the beast, but you take Lander and some of these other counties, there's, the guys that are there you probably don't want that aren't working, so thank you.
Thank you, Senator. Do we have any other questions on Assembly Bill 480 from the committee? All right. I will note that I had discussions with Ms. Reba and Mr. Hickman this morning and yesterday, and they have sent to me, and I apologize for not getting it to the committee. We're trying to post it on Nellis right now, but I know that you had proposed an amendment to the bill, that very complicated amendment that would change one word, and it's the effective date. And right now, the effective date would be this act becomes effective on July 1st, 2021, and you are proposing to change that to October 1st, 2021. Is that correct?
Thank you, Chair Brooks. That is correct. We are asking that the effective date be October 1st, and the reasoning is that we're going out to the rural counties right now to help them set up their plans of how they're going to do these things. And the rural counties are reliant on the judge, and they don't have that administrator to approve these fees yet. So we're hoping to be able to help build that into the plans, but the plans are due to our department on September 3rd. They'll go in front of our board at the end of September and likely be effective October 1st, which would coincide with the date of this bill. If we continue with the July 1st, the counties might not be set up to be able to handle the assignment of cases by, if someone, it would fall on our department, which we're willing to pick up, but we are short-staffed, and we just want to be able to help those rural counties get set up and everything in place so they feel more comfortable.
Thank you. Do we have any questions on that? Senator Goicoechea?
Thank you. And in defense of the rural counties, clearly they're waiting for this session to get over, which is June 1. So if you had a July 1st effective date, they'd have 30 days to get their plan in place. Way too quick. I appreciate your amendment. Thank you.
All right. Do we have any other questions on the bill, on Assembly Bill 480 or the proposed amendment? All right. Seeing none, thank you for joining us this morning. And we will move into support for Assembly Bill 480. Good morning. Go ahead.
Good morning, Mr. Chairman. John Pure from the Clark County Public Defender's Office, also testifying on behalf of the Washoe County Public Defender's Office. We'd like to thank the Department of Indigent Defense for bringing this bill forward and then also addressing our concerns. For the Clark County Public Defender's Office, our main concern was in Section 15, subsection 6, and the amendment they put in the earlier House addressed that amendment, addressed our concern, basically making sure that employees that work for us stay in the merit personnel system. It is something that we fought a long time for, to make sure that we have pay parity with the district attorney's office. There's a couple counties around the nation where public defenders do not have pay parity with the district attorney's office, and you wind up losing good talent. And it's important for a robust system to have good talent on both sides of the aisle. Secondarily, I just wanted to comment on some of the judicial independent pieces that Ms. Reba had talked about. Prior, back in the day, before Phil Cohen took over our office down in Clark County, Morgan Harris was the public defender. And what happened was we would put inexperienced lawyers on cases that they were not adept to handle. You'd come to the office, you'd be a lawyer fresh out of law school, you'd get a murder case. And what happened is somebody wound up getting wrongfully convicted. Our county got sued for $5 million. And the National Legal Aid and Defenders Association came in and went through a whole framework. And one of the things was pay parity. That was important. But they also found that independence from the judiciary is important to a system because attorneys in our office were judicially captured. They were more interested in pleasing the judge than putting forth a robust defense. And this bill helps take us in that direction. So I strongly urge your support of this bill.
Thank you. Do we have anybody else here in the room in support of Assembly Bill 480? All right. Could we go to the telephones and see if we have anyone in support of Assembly Bill 480?
Certainly. Thank you, Chair. To testify in support on Assembly Bill 480, please press *9 to take your place in the queue. Caller with the last three digits, 663. Please slowly state and spell your name for the record. You have 2 minutes and may begin.
Good morning, Chair Brooks and members of the committee. My name is John McCormick, JOHN-MCCORMICK. I'm the Assistant Court Administrator at the Supreme Court's AOC. And as the Director mentioned, a lot of the recommendations found in this bill kind of originally started with our Indigent Defense Commission and that series of 80 KT 411 orders. So I am just calling to support the bill and its furtherance of indigent defense improvement in the state. Thanks.
Caller with the last three digits, 080. Please slowly state and spell your name for the record. You have 2 minutes and may begin.
Hi, my name is Jim Hoffman, JIMHOFFMAN, representing Nevada Attorneys for Criminal Justice. NACJ supports AB 480. As the committee knows, we've been working on indigent defense funding and administrative issues related to that in Nevada for the past few sessions. This bill is another step in that project. NACJ believes that this bill will do a better job of providing competent and constitutionally effective counsel to defendants throughout the state. We therefore support it. Thank you.
Chair, the public line is open and working. However, there are no additional callers at this time.
Thank you. So do we have any callers in opposition?
Chair, the public line is open and working, and there are no additional callers at this time.
And do we have any callers in neutral?
Thank you, Chair. The public line is open and working. However, there are no additional callers at this time.
Thank you. And do we have anybody in opposition here in the room? Do we have anyone in neutral here in the room? All right. Seeing none, we can close the hearing on Assembly Bill 480. And thank you for coming in this morning. And now we will introduce a couple of BDRs, and staff will distribute the first BDR, and we will walk through that BDR. Similar to what we did the other day with the K-12 funding BDR, we'll go through the BDR and walk through the components of it before we introduce it.
Mr. Chair, so the committee has before them the BDR for the Capital Improvement Program bill, the CIP bill. Mr. Brody Leiser is coming down from Ways and Means right now, which is meeting to come walk the committee through the bill, so he'll be here in just a minute or two. It's also being posted online on Nellis. For those that are viewing the committee online, the BDR will be available shortly as an exhibit on Nellis.
Thank you, Mr. Thorley. That gives the committee a moment to look through the BDR, and we'll wait until Mr. Brody gets here, or Leiser gets here, and then we'll walk through it when he gets here. But please take this opportunity to take a look, or read through the BDR. Good morning, Mr. Leiser. How you doing?
Good morning. Doing well. It's a little intimidating walking down the ramp into the pit.
You were sitting in my least favorite seat in this entire building.
I pull a mouse out of my pocket. Chair Brooks, for the record, my name is Brody Leiser, Fiscal Analysis Division, and I'm here to present to you and the members of the Senate Finance Committee the BDR that implements the 2021 Capital Improvement Program. Just as a reminder to members, the Money Committees approved funding in a total amount of $413.1 million for the Capital Improvement Program, $75 million to launch the State Infrastructure Bank, and $44 million for resource conservation and preservation programs of the state. The major funding sources that support the Capital Improvement Program include $409.5 million of general obligation bonds, $45.7 million in agency funds, $61.9 million in federal funds, and $14.9 million in state highway funds. And BDR S-1172, that I believe you all have a copy of, implements the Capital Improvement Program. So if it's all right with you, Chair Brooks, my intention is just to do a section-by-section walkthrough of the bill, and then if there are any questions, happy to address those. Before I begin, I would note that there are several projects that have been approved in the Capital Improvement Program that contain multiple funding sources, and therefore you will see them in multiple sections of the bill. Section 1 of the BDR that begins on page 1 appropriates $14.9 million in highway funds to support 5 DMV projects and 1 public safety project in the 2021 CIP identified under this section. Section 2 of the BDR on page 2 limits the authority for expenditure through June 30th, 2025, and establishes a reversion of any remaining funds for the projects identified in Section 1. CIP projects typically have a 4-year period in which funds are appropriated and or authorized for, and therefore this section provides for that time period. A similar language is included in Section 5 to address reversion of general obligation bond authority. Section 3 of the BDR on page 3 restricts the transfer of funds from the highway fund for the projects identified in Section 1 until contract payments are required. Section 4 of the BDR authorizes $280.6 million in general obligation bonds for projects which are identified under this section. The section also reallocates $9.8 million of bonds previously issued under prior CIP legislation. This includes $505,932 from 2015 and $9.3 million from 2017. This allows for bond proceeds that were already issued to be spent before the proceeds of any new bonds issued pursuant to this section. Beginning on page 4 is a list of the capital improvement projects that are authorized to have bond funds support their project expenditures. Just for the members in the BDR, you'll see that these projects are grouped by agency. So on page 4 begins the projects for the Department of Administration. Moving on to page 5 begins projects for the Department of Conservation and Natural Resources. In Department of Corrections begins on page 6. The Department of Health and Human Services starts on the bottom of page 7, carries over to page 8. Then the Office of Military on page 8. The capital improvements for the Nevada System of Higher Education. The bonding authority begins on page 9. And on page 10, there are projects for the Department of Public Safety, the Department of Tourism and Cultural Affairs, and Department of Veterans Services. And lastly, under this section is the Department of Wildlife on page 11. Section 6, beginning at the bottom of page 11, specifies that the State Board of Finance will issue general obligation bonds for the 2021 CIP when it is deemed appropriate. Subsection 2 allows the state controller to advance general fund money if bonds have not yet been sold to finance the projects approved in the 2021 CIP. If general funds are advanced, the amounts must be immediately repaid to the general fund upon issuance of the bonds. And subsection 3 requires written notification from the Director of the Office of Finance to the State Controller, State Treasurer, and the Senate and Assembly fiscal analysts if a general fund advance has been approved and a reconciliation demonstrating that the general fund has been reimbursed. Section 7 begins at the bottom of page 12. This section authorizes $107.7 million from funding sources other than the general fund or the state highway fund for projects identified in this section. This includes authority for federal funds, agency funds, and university college funds. Subsection 2, which is on page 16 of the bill draft, requires the State Public Works Division to not execute a contract for construction of a project approved in the 2021 CIP that includes authorized non-state receipts until the State Public Works Division has determined that the non-state funding authorized has been awarded and/or is available for expenditure. Section 8 of the BDR requires that the State Public Works Division use only qualified personnel to execute the 2021 capital improvement program. Section 9 requires state and local government entities to cooperate with the State Public Works Division in carrying out the provisions of the capital improvement program. Section 10 approves $4 million in bonds for the Cultural Centers and Historic Preservation Grant Program. On page 17, sections 11 and 12 approve a total of $12 million for the Lake Tahoe Basin Environmental Improvement Program. Section 13 approves $8 million in bonds for the Water Infrastructure Grant Program. And Section 14 approves $20 million for conservation programs authorized under AB 84 that was approved during the 2019 legislative session. Section 15 of the BDR on page 18 provides additional explanation that it is intended that the bonds issued under sections 11 through 14 are exempt from the constitutional debt limit. Section 16 provides for the issuance of $75 million in general obligation bonds to launch the State Infrastructure Bank. This section also authorizes $485,124 in unobligated reserve interest earnings in the Consolidated Bond Interest and Redemption Fund to support operating expenditures of the State Infrastructure Bank. On page 19, Section 17 approves ad valorem taxes for the referred to as the Question 1 or the Q1 bond program, the conservation bond program established through AB 84 of the 2019 session, and for general obligation debt service. For the state's general obligation debt, 16.18 cents on every $100 of assessed valuation will be used to support existing general obligation debt of the state for prior bond issuances and for the bonds that are sold for the CIP. For the Q1 program and the conservation bond program established through AB 84 of the 2019 session, 0.82 cents for every $100 of assessed valuation will be used to support the bonds that were sold for the Q1 program and that will be sold for the conservation bond program established through Assembly Bill 84 of the 2019 session. The overall rate of 17 cents per $100 of assessed valuation remains the same as approved for the current biennium. Section 18, that begins at the bottom of page 20, requires that the state treasurer will estimate sufficient funding and determine whether that amount exists in the consolidated bond interest and redemption fund to pay the principal and interest on past CIP issuances as well as current issuances. If there is not enough money in the consolidated bond interest and redemption account, the treasurer can request of the state controller to reserve money in the general fund to pay those debts. Section 19 on page 21 of the bill draft request authorizes the State Board of Finance to pay expenses related to the issuance of general obligation bonds. Section 20 on page 22 authorizes money to pay for bonds in the consolidated bond interest and redemption account. This amounts to $155.4 million in fiscal year 2022 and $143.3 million in fiscal year 2023. Section 21 authorizes the State Public Works Division in the Nevada System of Higher Education, with the approval of the Interim Finance Committee, to transfer money from one project to another within the same agency. Sections 22 and 23 began on page 23. These sections revise the reversion language from prior CIP legislation to allow for the reallocation of bonds issued under prior authorization approved by past legislatures for use for projects identified in Section 4. And Section 22 also extends the reversion dates, thereby extending project authority for 2 years for the projects listed in this section, beginning at the bottom of page 23. Sections 24 through 27, which began on page 25 of your bill draft, these sections extend the reversion dates, thereby extending project authority for 2 years. In total, there were 12 project extensions that were approved by the money committees. And all 12 of those projects were from the 2017 CIP that would have otherwise had their authority expire at the end of this fiscal year. Section 28 on page 27 revises the reversion language from prior CIP legislation to authorize for the reallocation of bonds issued under prior authorization approved by past legislatures for use for projects identified in Section 4. And finally, Section 29 of the bill draft requests this act. The effective date is upon passage and approval.
Thank you, Mr. Leiser. Do we have any questions from the committee on this BDR? Is there anything at all in this BDR as drafted that is not 100% consistent with the decisions made in the subcommittee and the full committee?
No.
Thank you. Senator Kekeffer?
And as a follow-up, is there anything that's inconsistent or a change from previous practice or a deviation from previous policy in CIPs approved in years past, maybe with the exception of the infrastructure bank?
For the record, Brody Leiser, the answer is no. The one thing I will note, though, for members, for those that are familiar with seeing the language in the CIP bill, we did add clarifying language. And if you look in Section 4, on page 4, the latter part of the paragraph, We did include a definition of proceeds of general obligation bonds this biennium to clarify that the funds that are being authorized and approved by the legislature include both define the proceeds of general obligation to mean both the proceeds that are received upon sale of an issue and any interest that's accrued on those proceeds, as the state will go out to issue for its first tranche this fall. But not all of those dollars are going to be spent immediately, and therefore they will earn interest. And those interest earnings are allowable to be expended on projects under the federal guidelines and requirements. And so there is language added this biennium to clarify that in the CIP legislation. And you will also see that in sections, I want to say 10 through 14, but just to make sure I get it correct, 10 through 14, as well as section 16, also has similar language. So Senator Kekeffer, that was a long way to tell you no, but I want to point out that you will see different language compared to prior legislation.
I appreciate that. Quick follow-up, Mr. Chair. Brody, can you also, I'm sorry, Mr. Leiser, can you also walk me quickly again through the specific authorities in sections 10, 11, 12, 13, 14? They were primarily the tranches out of the conservation component, I think, but I just wanted to make sure I was associating with the right ones, because there was some reference to bills from the current session.
For the record, Brody Leiser. So section 10 approves bonds for the Cultural Centers and Historic Preservation Grant Program. That's on page 16. Sections 11 and 12 authorize bonding for the Lake Tahoe Basin Environmental Improvement Program. And section 12, Senator Kekeffer, as you note, does reference a bill from this session. The initial authorization of the Tahoe Environmental Improvement Program bonds authorized, I believe, a total of $100 million in bonds. The initial authorization language requires that either, I believe, the IFC or legislation be approved to specify how those bonds would be used. And so under section 12, you'll see a reference to Senate Bill 368. Senate Bill 368 specifies how this particular $4 million of bonds would be used under that program. Section 13 are $8 million in bonds for the Water Infrastructure Grant Program. And then section 14 is the $20 million that are approved for the conservation programs that were authorized under Assembly Bill 84 of the 2019 session.
Thank you for that. And are all of those components outside of the debt restrictions?
So section 15, sorry, for the record, Brody Leiser. Senator Kekeffer, sections 11 through 14, except for the bonds that would be used pursuant to subsections 3, 5, and 6 of section 14, would be excluded from the constitutional debt limit. And so it does, the bonds for the Cultural Centers and Historic Preservation Grant Program do count against the debt limit. The other programs generally do not apply to the constitutional debt limit, with those exceptions that I noted, and the exceptions are also identified under section 15. of this bill draft on page 18. And the exceptions under the AB 84 program that are listed in section 15 of this BDR are consistent with the exceptions that were memorialized in AB 84 of the 2019 legislation.
Appreciate that. And then so when I look at sections 11 and 12, that's a total of 12 million in the Tahoe EIP program. Those are not inclusive. Those are, I would add those together, right?
That is correct.
Senator Severs-Ganser, go ahead,
Thank you,
please.
Chair Brooks. So I'm looking at section 11, and it refers to $8 million, and then it points to section 1 of chapter 167 of NRS. And I thought you'd said that was Tahoe Basin, but when I looked up 12 goes to Tahoe Basin, but 11, chapter 167. Am I reading that right?
Thank you. For the record, Brody Leiser, Senator Severs-Ganser, you are reading that correctly. So the $8 million is part of the overall $12 million of the Tahoe Environmental Improvement Program. And so similar to the discussion on the reference under section 12 to a Senate bill this session, I'm going off memory, I'm 99% sure. Assembly Bill 220 of the 2019 legislative session was approved, and the Assembly Bill 220 of 2019 again specified of the initial $100 million that was authorized for this program, specified how this particular $8 million is going to be used. And so the reference under section 11 to the 2019 statutes go back to that bill.
Thank you. So I'm looking at Nevada revised statutes that are current right now, and maybe they don't tie the same way. Chapter 167, it says transfers to minors. So that's why I'm having a hard time tying it, is because I'm actually pulling up the NRS. So I just want to make sure the chapter's right.
Senator Severs-Ganser, Wayne Thorley, for the record. The Chapter 167 references to statutes of Nevada, not Nevada revised statutes. So that's why you're not seeing it tying in NRS.
Okay. Thank you. I'll double check it. Thanks.
Thank you. Do we have any other questions for Mr. Leiser on this BDR? All right. I do not see any, so I appreciate it, Mr. Leiser. And we will take a little bit of a break, and we'll hand out the next BDR for our review. And before you go, though, what is the total amount represented in this? And I know you'd mentioned earlier, but I forgot it, what you said of bonding represented by this entire this CIP BDR.
For the record, Brody Leiser, $409.5 million in general obligation bonds.
What does that represent relative to other sessions? When's the last time that we have done this much?
I have that information. If you just give me 1 second, please.
I knew
Mr.
you
Chair.
would.
For the record, Brody Leiser. Well, I'm gonna have to try and pull up the information. I can tell you in total for the capital improvement program, and compared to prior sessions, the 2019 legislative session approved a total of $347 million. In the 2017 CIP program, it was $407.6 million. The 2015 CIP program was $215.3 million. And 2013 was $102.7 million. Going back to 11 was about $53 million. And so this is the largest CIP in quite some time. And if you give me a second, I will pull up the amount of bonding that's been approved. I believe I can get that fairly quickly, and I apologize for the delay here.
Oh, no, I appreciate that.
Hopefully you can't see the sweat perspiring on my forehead. The 2017 CIP included general obligation bonds, new issuances of around $115 million. That was new issuances. In the 2017 CIP, there was also a reallocation of approximately $12 million. In the 2019 CIP, in total, the general obligation bonds to support the capital improvement program was approximately $189 million in general obligation bonds.
Thank you. And in this session, what the total of new general obligation bonds is how much?
To support the 2021 CIP, the Money Committee's approved a total of new general obligation bonds of $355.6 million. In addition to that, there was a reallocation of $9.8 million of bonds from prior CIP. And in addition to that, there's the $44 million of general obligation bonds that are approved for the conservation and natural resources programs.
Thank you, Mr. Leiser. Do we have any other questions from the committee? And thank you for the on-the-spot research for us. I appreciate that. All right, I do not see any, so we will distribute the pay bill BDR and give the committee a chance to look at it. And I think we have almost the entire fiscal team here in the room this morning. It's good to see you in person. And before we get started with the pay bill BDR, I just again want to thank Mr. Leiser for walking us through that. This is this amount of bond new bond issuance is, I think, speaks to exactly why we need to be very thoughtful about what our credit rating and our bond rating looks like this session, and some of the decisions that we're going to make in the next few days, that could do to that.
Mr. Chair.
Senator Seavers Ganser.
Just a comment, when I was going through all the numbers or reviewing them, so much of it's maintenance. I feel like we're doing a lot of catch-up. There's only a couple of big projects, the UNLV Engineering School, and there's a National Guard Center, and most of them are like smaller, but it feels good to be able to sort of catch up on some of the deferred maintenance.
Yes, absolutely. I think that's a perfect way to spend our money and our bond obligation. And we have been deferring it for a very long time. Some of those decisions we've seen come before us several times now, and I'm glad to see that we're taking care of that. All right, we are ready to go, and we are joined this morning by Ms. Hoppy and Ms. Malone. And whenever you are ready to walk us through this pay bill BDR, just go ahead and get started.
Thank you, Mr. Chair. For the record, this is Karen Hoppy with LCB Fiscal Analysis Division, and with me is James Malone on my team, and also a key contributor to preparation of the pay bill for this session. The committee should have a copy of the BDR in front of them, as well as a one-page exhibit. And both these items should be posted on Nellis at this time. So, Mr. Chair, with your permission, staff will walk through each section one by one through the BDR, and then stand for any questions the committee may have after that. Starting on section 1, this sets forth the maximum annual salary amounts for employees in the unclassified service of the state, as approved by the money committees. These amounts include the 3% cost of living adjustment, or COLA, approved for fiscal year 2020, but do not include any COLA that may be approved for the 21-23 biennium. Section 2 starts in the BDR on page 34. Section 2 is standard language that allows the Division of Human Resource Management, Department of Administration, to review the duties and responsibilities of a position that may have been omitted from the bill to establish the salary of that position. Section 2 also allows for corrections to the bill for any errors determined by the Fiscal Analysis Division with approval of the Interim Finance Committee. This section also includes standard provisions regarding persons filling or vacating unclassified positions. The next sections of the pay bill address COLAs for state employees, organized into separate sections because of funding source and type of position. In total, the pay bill includes $17.1 million in general fund appropriations and $3.1 million in highway fund appropriations to fund the COLAs. Sections 3 to 4, which are on page 35 of the BDR. Section 3 provides that the unclassified positions listed in Section 1 will receive a 1% COLA in fiscal year 2023, and Section 4 appropriates $520,936 general fund and $42,369 highway funds for this purpose. Moving on to Section 5 on page 36. Section 5 addresses COLAs for the classified and non-classified positions in the executive branch and judicial branch that are funded with general funds. And $11.8 million is appropriated for this purpose. In discussions on the next few sections, I would refer to the committee to the one-page exhibit, which shows the various collective bargaining units for reference as we go through the sections. Fiscal staff would note that the 2021 pay bill is the first to include provisions related to collective bargaining for state employees, which was authorized by SB 135 of the 2019 session and codified in NRS 288. SB 135 granted certain classified state employees in the executive branch, including the Nevada System of Higher Education, the right to organize and choose representatives for the purpose of engaging in collective bargaining. This right was not granted to employees in the legislative branch or judicial branch. SB 135 required the Government Employee Management Relations Board to establish bargaining units for 11 occupational groups, designated as Units A through K, and to determine the classifications of employees within each bargaining unit. At this time, 7 of the 11 authorized bargaining units have an exclusive bargaining representative, and of the 7 units with representation, 6 units have negotiated a collective bargaining agreement that was approved by the Board of Examiners by May 25th, 2021, which was yesterday. Funding for the general fund portion of COLAs approved for these 6 units is included in this section. Subsection 2 on page 37. For personnel not represented by a collective bargaining agreement approved by the BOE by May 25th, 21, a COLA of 1% in fiscal year 2023. Subsection 3, for personnel represented by Unit A, a COLA of 3% in fiscal year 2023. Subsection 4, for personnel represented by Unit E, a COLA of 3% in fiscal year 2023. Subsection 5, for personnel represented by Unit F, a COLA of 3% in fiscal year 2023. Subsection 6, for personnel represented by Unit I, a COLA of 3% in fiscal year 2023. Subsection 7, for personnel represented by Unit H, a COLA of 2% in fiscal year 2023, in addition to the increase in salary provided to non-represented personnel. Additionally, this group would receive a one-time bonus in July 2022 of $500 for personnel with 5 to 15 years of service, and a one-time bonus of $1,000 for personnel with more than 15 years of service. In subsection 8, for personnel represented by Unit K, a COLA of 3% in fiscal year 2023. Moving on to section 6 on page 38. Section 6 addresses COLAs for the classified and non-classified positions in the executive branch and judicial branch that are funded with highway funds, and $3.1 million is appropriated for this purpose. 2 of the bargaining units with approved agreements have personnel who are supported with highway funds. So in subsection 2 on page 39, for personnel not represented by a collective bargaining agreement approved by the BOE by May 25th, 2021, a COLA of 1% in fiscal year 2023. Subsection 3, for personnel represented by Unit A, a COLA of 3% in fiscal year 2023. And in subsection 4, for personnel represented by Unit H, a COLA of 2% in addition to the increase in salary provided to non-represented personnel. Additionally, this group would receive the one-time bonuses mentioned earlier of $500 for personnel with 5 to 15 years of service, and a one-time bonus of $1,000 for personnel with more than 15 years of service. Staff would like to note for the committee there is an error in this section that will be corrected before the bill is formally introduced. And that is back on page 7. So this was in subsection 5, and I forgot to mention it earlier. Page 37, subsection 7. Line 2 should read, an increase in salary of 2% in addition to any increase in salary approved for non-represented personnel. Moving on to section 7, which is found on page 40 of the BDR. Section 7 authorizes COLAs of 1% in fiscal year 2023 for the classified and professional positions in the Nevada system of higher education, appropriating a total of $4.4 million for this purpose. The appropriation for NSHE COLAs is based on the proportion of appropriations from the general fund to total revenue within each state-supported budget of the NSHE. Section 8 on page 41 authorizes COLAs of 1% in fiscal year 2023 for personnel of the Legislative Council Bureau, appropriating general funds of $318,591 for this purpose. Section 9 is standard language related to plans for on-call pay for the Department of Health and Human Services and the Department of Corrections for unclassified physician positions. Section 10 on page 42 is standard language related to plans for credential pay for the Nevada Gaming Control Board. Section 11 is standard reversion language applicable to the previous sections. And Section 12 is standard language governing the distribution of monies by the State Board of Examiners to budget accounts. Section 13 on page 43 authorizes the State Board of Examiners to reimburse from the $18,659 general fund appropriation in this section for any deficiencies created between funding appropriated to Tahoe Regional Planning Agency and the 1% COLA approved for its employees for fiscal year 2023, conditioned upon the state of California providing the required 2-for-1 match. Section 14 lists the positions exempt from the provisions in Nevada revised statutes that requires the salary of a person employed by the state not to exceed 95% of the salary of the governor. Section 15 on page 44 is generic language to provide for the alignment of agency or position name changes enacted by the legislature this session through other bills with the agency or position names in this pay bill. Section 16 amends statute to add authorization for the new Dieter unclassified position of Deputy Staff Attorney, which was approved by the money committees. And finally, Section 17 provides this bill becomes effective on July 1st, 2021. And Mr. Chair, that concludes staff's presentation.
Thank you, Ms. Hoppy. Do we have any questions on this BDR from the committee? Senator Kieckhefer?
Thank you, Mr. Chairman. Appreciate it. Since this is the first time we're working through all the provisions of the collective bargaining provisions, I have some questions on that front. So, is there a set cost associated with the increases in pay beyond the 1% well, let me start with this. In section, I guess 5 is where it starts. Are those increases effective in fiscal year 23 or fiscal year 22?
Senator Kieckhefer, these increases would be effective in fiscal year 2023.
Okay, so that's consistent with the 1% that COLA that the governor's submitted as a budget amendment?
Yes, Senator, that is consistent with the governor's budget amendment.
Okay. In subsection 7 of section 5, you made the verbal correction to the line of 2% in addition to any increase in salary approved. Why is that a change?
Senator Kieckhefer, a similar provision is in the following section, section 6, and the intention of this language is to provide flexibility to the committees should any additional bill be approved or submitted to increase the statewide COLAs to any different amount. So did not want to be tied to the amount of COLA for statewide that's included in this bill.
Is that because the collective bargaining agreement ties it to a 2% increase above what everybody else gets? I don't understand.
Yes, Karen Hoppy, for the record, the way that the agreement is written for this particular bargaining unit, it reads, in addition to any COLA approved for statewide personnel or something to that effect. So under the provisions of this bill, that unit would get 3% right now. However, if statewide personnel were to be approved for, or non-represented state personnel would be approved for a 2% COLA, for example, this particular bargaining unit would get 2% statewide plus 2% that's in their agreement for a total of 4%.
So the way I read the chart that you've got, that we've got provided to us in terms of the number of authorized positions with no exclusive representation and those that are not captured in the categories listed A through K, my quick math is that 16,472 positions would be at the 1% in 2023, and the remainder, like 7,000 positions, would be captured by the provisions of the different bargaining agreements. Is that right?
Senator Kieckhefer, fiscal staff's calculations would be that 25% of the authorized executive branch positions are covered by an approved collective bargaining agreement. Approximately 75% are not, and then would get a 1% COLA.
So if, do you have a dollar value associated with the difference between a 1% COLA applied across everyone and the terms of the collective bargaining agreements?
I'm sorry, could I ask you to clarify that a bit more?
So if we were to apply 1% to all 23,000 positions as compared to what's in the pay bill, what's the delta in terms of a dollar value?
Right, Mr. Malone will correct me if I get this wrong, but if the entire state were to get 1% COLA, general fund appropriations, that would be, instead of 17.1 million, approximately $10 to $11 million for 1% for the entire state. The way this is laid out in my chart, 6.4 million of this total represents the extra 2% that would be granted under collective bargaining out of the 17.1 million, if that's helpful.
Yeah, I think that's the number I was looking for. So of the total amount of salary increases that are contained in the bill, let me start again. What's the total dollar value of all salary increases contained in the bill?
Senator Kekeffer, the total is 17.1 million general fund, 3.1 million highway fund. And to reiterate or expand on what I just said, of the general fund portion, 6.4 million represents the extra 2% for collective bargaining, and for the highway fund portion, 727,000 approximately represents the extra 2% for collective bargaining and highway funded positions.
Okay, that's what I was getting at. Thank you. So if, as I recall the bill being passed, right, the legislature retains control over final decision-making over the fiscal impacts of the collective bargaining agreement. So if, for example, the legislature wanted to give parity to those non-represented employees, we could theoretically increase that COLA in the second year for non-represented employees to 3% and not impact the subsections of sections 5 and 6 that address the collective bargaining agreements, correct?
That would be correct. Any decision such as that by the legislature would only affect the non-represented personnel, which are called out in subsection 2.
And then that change that you verbalized in subsection 7 would have to be readdressed, right?
Yes, for the one bargaining unit, which has an in addition, 2% in addition, it would be on top of whatever is approved for statewide.
Thank you, Ms. Hoppe. I appreciate it. Thank you for the leeway, Mr. Chair.
Senator Dennis?
Thank you. I just have a real quick clarification on page 35, section 3. I may have just heard it wrong, but you mentioned a date there. Were you talking about the effective date, or were you talking about a fiscal year?
Karen Hoppe for the record, and Senator Dennis, page 35. I'm sorry, which section?
Section 3. We're talking about the approximate maximum salary set forth, and then it's got the effective date.
Yes, Senator Dennis, this section refers to the maximum salaries in section 1, which are the unclassified positions of the state, and those are to be increased by 1% in fiscal year 2023. And this is consistent with the statewide 1% for other classified personnel that's described in sections 5 and 6.
Great. Thank you. Thank you, Mr. Chair.
Thank you, Senator. And do we have any other questions from the committee on this BDR? Senator Sievers-Gansert.
Thank you, Chair Brooks. So kind of understanding those contracts again, if they're whatever the state is plus 2%, if we catch up employees outside of collective bargaining to 3%, do the others go to 5?
Senator Sievers-Gansert, if, for example, the statewide employees were brought up to 3%, all the other collective bargaining agreements would also stay at 3%, except for this one unit that has a provision that says 2% on top of the statewide. In that case, it would be 5% for that one unit.
And what's that one unit? Or how many employees are in that unit?
Let's see. I'm looking at the exhibit, so I want to call out exactly the correct one for you. This would be Unit H, and this is representatives of the Category 2 police officers Information provided to fiscal staff by Department of Administration is there are 134 employees in this bargaining unit.
Thank you, that's helpful. And then kind of going back to the numbers, it was 17.1 million for, was the budget, the general fund budget for all the raises that are currently anticipated. And 6.4 of that was for the extra 2%. So if you take that off, it's 9.7 million. So is it 9.7 million per point? Am I doing that right? So if you went from 1 to 2, is it about $10 million every time you increase 1% across the board?
James Malone, LCB Physical, for the record. That would be an approximation, but pretty close.
Okay, thank you.
Thank you, Senator. Do we have any other questions from the committee? Senator Ratty?
Just because I'm apparently not capable of tracking that, so just ask it more directly, what is the dollar amount to achieve parity?
Thank you, Senator Ratty. Staff has estimated that in order to provide COLAs of 3% to all employees in the state, total general fund would be approximately $32 million versus the $17 million that is recommended in this bill.
So the delta between those two numbers?
Senator Ratty, that's roughly $15 million to increase to 3% statewide.
Thank you.
Chair Brooks, that's not exact. So when we just talked about a point, it was about $10 million. So I just want to make sure that number's right. Okay, because they already have it. Okay, all right. Thank you.
Thank you. Do we have any other questions? Good. All right. Thank you. Appreciate Ms. Hoppy and Mr. Malone. Do we have, and so next up, so no other questions on that BDR, and the next up will be a BDR that will be introduced by the Senate, and it is Authorizations Act BDR. Good morning, Ms. Day. How you doing? Good to see you in person.
Good morning, Mr. Chair. You too.
All right, committee, in front of you, you have BDR S1171, authorizing expenditures by agencies of the state government for the 21-23 biennium. And we have Ms. Day here to present this to us, and go ahead whenever you're ready.
Thank you very much, Mr. Chair. Good morning, Mr. Chair, members of the committee. For the record, Stephanie Day, Fiscal Analysis Division. The Bill Draft Request 1171 is the Authorizations Act. The Authorizations Act provides funding and authorizes the expenditures of funding other than state general fund appropriations or state highway fund appropriations. The bill draft implements the budget as approved by the many committees. The funding sources include federal funds, self-funded budgets receiving money through fees or other means and outside revenue sources such as licensing fees, gifts, grants, interagency transfers, and other funds, which total $28.11 billion over the 2021-23 biennium. This amount includes $2.83 billion in federal funding, inclusive of anticipated American Rescue Plan funds in the COVID-19 relief program budget, and $1.36 billion in federal funding provided for pre-K through 12 education in response to the COVID-19 pandemic. Additionally, due to the specific statutory language for these agencies, the bill draft includes authority for the Nevada Gaming Control Board and the Nevada Gaming Commission to expend $63.9 million from the general fund over the 2021-23 biennium. Similarly, the bill includes authority for the Nevada Department of Transportation to expend $900.6 million from the Highway Fund over the 2021-23 biennium. Section 1 begins on page 1 of the bill with the amounts per budget account beginning on Section 2. I did want to bring to the attention of the committee, on page 2 is the COVID-19 relief programs budget. In the first year, the amount is $2.829 billion. The second year is $2.738 billion. The second year is actually a balance forward. The funds are in reserve in that account in the first year, therefore they balance forward to the second. So that is not duplicative. The amounts per budget account go all the way through page 23. So section 2 is beginning on page 23 of the bill. Section 2 is related to the tobacco settlement funds, and it does include tobacco enforcement operations for the Attorney General Special Litigation Account. Sections 3 and 4 begin on page 25 of the bill. They authorize the specific amounts of general funds for the Gaming Control Board and Gaming Commission previously mentioned. Section 5 is on page 26 of the bill, the draft, excuse me. Section 5 authorizes the amounts to be augmented in compliance with the State Budget Act, including work programs and the provisions related to the IFC process for work programs. Section 6 on page 26 authorizes the reduction of the amounts if the authority is in excess of amounts to be received. Section 7 is on page 27. Section 7 states that, except as otherwise provided in other sections, if additional funds are received in budgets funded through general fund and/or highway fund appropriations, the general fund and/or highway fund appropriations must be decreased accordingly. And there are quite a few sections within this that do apply to that that I will be going over. On page 27 is section 8. It is related to the fees and tuition collected by the Nevada System of Higher Education, and those are exempt from section 7. Section 9 begins on page 29 of the bill. It is related to, the bill draft request. Section 9 is related to funds collected from Carson City and Story County for the public defender. Section 10 is on page 30. It states that the tax on motor vehicle fuel computed to be used on watercraft shall be allocated equally to the Department of Wildlife and to state parks. On page 30 also is section 11. The Division of Forestry, costs of repair and maintenance of firefighting and emergency response vehicles are exempt from the provisions of section 7. Also on page 30 is section 12. It is the legislature's intent that funds in the state fire marshal's budget from the contingency account for hazardous materials are spent on eligible training programs and related operating expenditures before general funds. Beginning on page 31, sections 13, 14, and 15 are expenditures that are detailed in the sections that are also exempt from section 7. Sections 13 and 14 are related to the Division of Forestry, and section 15 is related to the Western Interstate Commission for Higher Education Loans and Stipends budget, and is the health profession education program slots for that. Also on page 31 is section 16. The funds in the Emergency Operations Center budget account balance forward. They do not revert to the general fund at the end of a fiscal year. Section 17 is also on page 31. It is conforming language consistent with language in the Appropriations Act requiring the Division of Child and Family Services to revert specialized foster care funding in certain circumstances. Beginning on page 32 is section 18. It is also an exemption from section 7 for the Nevada System of Higher Education, that those funds may balance forward. Section 19 states that the Interim Finance Committee approval is not required on work programs related to bond repayment costs in the municipal bond bank revenue and debt service budgets. That is for the bond repayment costs only for those budgets, not for the other portions of those budgets. Section 20 states that when the fleet service vehicles purchased with general fund appropriations are sold, the proceeds are deposited into the general fund as opposed to the fleet services fund. Section 21, which is also page 32, states that the Public Employees Benefits Program shall not spend or obligate reserves in excess of the amounts authorized by the money committees when closing the budgets for the purposes of changing health benefits without IFC approval. Section 22, that's beginning on page 33, states that except for the remaining grant obligations, the balance in the catalyst account cannot be committed for expenditure after June 30th, 2023. Section 23, it's the legislative intent that funds in the Medicaid and checkup budgets shall be expended in order to continue the current service delivery model for prescription drugs, in which prescription drugs are generally not carved out of managed care. Also on page 33 is section 24. Additional funds received in the Medicaid or checkup budgets are exempt from section 7. Starting on page 34, it's actually 34, 35, and I believe, and part of 36. Sections 25 through 29 are all similar. They transfer funds from the Medicaid budget to the Healthcare Financing and Policy Administration budget to fund administrative costs if and only if other legislation is passed by the legislature and approved by the governor. Beginning on page 36 is section 30. That states that transfers from the Aging and Disability Services Division to the Board of Applied Behavior Analysis, if and only if Senate Bill 217 is passed by the legislature and approved by the governor. Also on page 36 is section 31, which allows for the balance forward of funds allocated from the Interim Finance Committee contingency account to forestry in fiscal year 2022. On page 37 is section 32. With respect to an officer or agency if the name has been changed or the responsibilities have transferred pursuant to other legislation passed by the legislature and approved by the governor, any reference in this act shall be deemed to refer to the language in the other act. And finally, Section 33 are the effective dates, and I would be happy to answer any questions the committee may have.
Thank you, Ms. Day. Do we have any questions for Ms. Day on this bill draft? Go ahead.
Thank you, Mr. Chairman. Ms. Day, on the PEB item, section 21, pages 32 and 33 of the draft, is that new language or is that consistent with what we've had in past biennia regarding their ability to use reserves to change benefit levels?
Senator Keykefer, for the record, Alex Hartz. That was language that was added last session by the money committees.
Okay, thank you. Section 23 on page 33, that is the that's the piece that requires Medicaid managed care to continue funding pharmacy benefits through the per member per month amount, and they don't carve out pharmacy benefits for managed care. Is that right?
Thank you, Mr. Chair. Through you to Senator Keykefer. Yes, that is correct.
Okay. Then it looks like starting on section 25, they all relate to specific pieces of legislation. Is each section an individual bill? Am I reading that right?
Mr. Chair, through you to Senator Keykefer. Yes, as a matter of fact, the individual bills are referenced in each of those sections. For example, section 25 is related to Assembly Bill 191.
Okay.
Section 26 is Assembly Bill 256.
And so on and so forth.
Yes.
Thank you.
Thank you.
Much appreciated, Mr. Chair. Actually, is there a total dollar figure associated with the Authorizations Act that you can give us? Because I don't think I heard that.
Yes. Thank you. For the record, Stephanie Day, Fiscal Analysis Division. The total authorizations is $28.1 billion dollars, excuse me. There's $900 million in highway fund, and then an additional $63.9 million in general funds, for a total of $29.1 billion in this bill draft request.
It's the big one. Thank you, Mr. Chairman.
Thank you. All right. Do we have any other questions from the committee? Perfect. Thank you, Ms. Day. Appreciate that. And do we, Mr. Thorley, do we need to introduce this right now? Because we will be taking a recess and coming back.
Mr. Chair, if you'd like to introduce this BDR right now, we can get it transmitted to the front desk for introduction on the floor later.
Perfect. I would take a motion to, I have a motion from Senator Dennis to introduce this bill draft 1171. I have a second from Senator Dondero Loop. Any discussion on that motion? All right. Seeing none, all in favor, aye. All opposed, nay. Motion passes unanimously, and we can introduce this bill draft. And with that, we will take a recess, and we will come back at the call of the chair, and I'll keep you all posted.